Hello, everyone, and welcome back to Coffee with Craig, where we talk about all things firearms policy, politics, culture, media, you name it. We're talking about it right here on Coffee with Craig. So please take a moment, like and share the program so that your friends can join in the conversation. Also, please make it a point if you haven't already done so, make sure that you hit the notification button on Facebook and YouTube. That way, you'll be notified as soon as we go live, and you can participate in the live chat as the program is taking place. All right, let's get into today's topic. You guys have seen this individual when we did the Bruin Symposium. Had a lot of information offer to the discussion, and now we are very excited to have announced that Cody Wisniewski has signed with FPC Law. He is now the senior attorney for constitutional litigation, and we have him now available on the program to talk a little bit about himself and a little bit about the new job that he's going to be doing here with FPC. Cody, welcome back to the program.
Thank you, Craig. Thanks for having me. I appreciate it.
Excellent. So, do me a favor. Tell us a little bit about your background, the work that you've done and the work that you've done kind of up to this point.
Yeah, so luckily I didn't really have to prepare to come on today since I'm just talking about myself. So hopefully I have that one down. This isn't quite like oral argument, I guess. But so as you said, so I'm Cody Wisniewski. I am the new senior attorney for constitutional litigation here at Firearms Policy Coalition. I've had the distinct pleasure of working with FPC in a lot of cases in the past and seeing kind of the work that the organization has done. And so when there was an opportunity to come and join the team for this crazy post Bruin push that we're seeing, all these new lawsuits, all these new issues coming to light, I couldn't contain myself. So I'm really happy to join. Background wise, I'm originally from Southern California. I always have to disclaim that I'm not one of those Californians, obviously. But I know many people who are following this are also from the state, so you guys fully understand. But went to law school in San Diego, University of San Diego, and initially went and actually worked for the federal government for a year, thinking that I could have some sort of impact from the inside, if you will. I actually didn't make it a full year. I made it 360 days before I realized that that was well and beyond a lost cause. And quickly transitioned into suing the federal government instead of suing on behalf of. So for the past 5 years prior to joining Firearms Policy Coalition, I worked at another organization where I did Second Amendment litigation. We worked on lawsuits with FPC, like I said. We worked in lawsuits in Colorado, California, New York. And so I'm really hoping to bring some of that experience to Firearms Policy Coalition and to kind of work with the team and build on it from there.
That is excellent. No, not a lot of people, and it's hard to explain this to folks who don't deal with a lot of litigation stuff, but uh, the law is oftentimes a lot like medicine, where you have people who have their various different specialties. And there aren't a lot of attorneys that really not only have a specialty in understanding firearms and firearms law, but really focusing on the constitutional aspect of it. What made you decide to get into that particular niche of the law?
Oh, wow. Maybe I should have prepared. Uh, so when I was in law school, those of you who've been through law school will know when you take constitutional law, what you learn constitutional law. You don't learn about the Constitution necessarily. You don't learn about what went into the drafting process or the ratification process of either the Constitution or the Bill of Rights. What you learn is what a group of Supreme Court justices said about what another group of Supreme Court justices said about what another group of Supreme Court justices said about eventually getting back to the text of the Constitution. I actually keep a constitutional law textbook in my office that was published in 1969. It's a two-volume set on con law, and the text of the Constitution does not appear in the entire textbook. And so it's a huge problem. When we started digging into the issues and we started actually looking at some of the court interpretation of the Constitution, that's when I really started to see the Second Amendment as kind of I like to call it the microcosm of the macrocosm. It is, the way that the Second Amendment goes is the way that the rest of the Constitution goes through the way that the court treats those rights and those protected rights. If you can relegate a part of the Bill of Rights that a judge might not like to a second tier status, then that sets dangerous precedents for everything going forward. So I was very interested in the issue in law school, and then kind of fell backwards into it. Like I said, I worked for the feds for a year, and then after leaving DOJ, I kind of realized that we needed to have people who were students of the Constitution, students of the Bill of Rights, students of the Declaration, who were also litigating attorneys, who were also the ones stepping up in courtrooms. And then taking on the firearms issue was natural for me. It was an interest area, and I also think it's really important to be a student of firearms and to fully understand as much as possible about their function, about their use, about their integration into society, about their importance in our culture, and to weave that into constitutional litigation.
Okay, so you brought up an interesting point because one of the things that I've always lamented has been the fact that there are so many judges who are making decisions, and I think if they understood the technology of firearms better, they probably wouldn't rule the same way. And a great example I had to do with magazine and magazine capacities. And when we would have the Attorney General's office explain, oh well, you can always just modify a magazine and yada yada yada. Well, why wasn't the judge asking about how difficult is it? Does it change the safety of the magazine? Stuff like that was rarely brought into the discussion. I thought when Judge Benitez, when he was looking at the AR-15 ban, once again, he really got into it, had them actually bring in the AR, had him bring it in, had him go through and talk about the specs and whatnot, and really work to understand the technology. Because in the end, the ruling they're making is not just about the right, but you only understand how the right is affected when you're affecting the technology. And the fact that you just brought that up, how big of an issue do you see that in some of these decisions that are being made?
Oh, it's massive. I mean, you're dead on. There are court opinions from decades past where courts are setting precedent based on clips when they're actually talking about magazines because the people in a courtroom don't know the difference. I mean, we've seen the treatment by, judges, by politicians of, the AR platform rifle as something that it's entirely not, right? I mean, the lack of understanding of what a, semi-automatic self-loading firearm is in some of these cases is make or break. And so I think it's really important. And one of the things that Firearms Policy Coalition thinks is really important is having people who know what they're talking about with firearms on these cases and working these cases. You don't want attorneys in the courtroom who, however well intentioned, don't know the first thing about firearm function, arguing about the appropriateness of a specific ban, of arguing about the appropriateness of magazine capacity, arguing about the different function of bump stocks like we've seen. There are all these different issues where if you don't know how a firearm actually functions and how different firearms actually function, then you're not going to be able to make effective or efficient arguments about them. And that's massive and incredibly important and something that we take very seriously.
Yeah, it's funny because you actually have people who know nothing about firearms making decisions, that are actually passing laws regarding these things. You have people who don't know about firearms in many cases or don't care uh, enforcing these laws. It would help that if we're going to establish the constitutionality of it, that we actually probably have someone who knows and understands it, who's making decisions or judging the constitutionality of some of these laws.
And the same thing is true of the Constitution, right? So not only do you have people passing laws, enforcing laws, and then reviewing laws that don't know about firearm function, and that's where the attorneys come in. It's our job to step into a courtroom and ensure that the judge knows everything that they need to know. But you have that same process happening with the Constitution and the understanding of the Constitution of the Bill of Rights. You have people sitting in Congress who are, admitting that they're not concerned about the constitutionality of bills that they're considering. That used to be just a blast from the past. That used to be the primary consideration in federal Congress when they were reviewing laws was, do we even have the authority to do this? Wouldn't it be an amazing day if we had that again? But you have people passing laws that don't understand constitutionality. You have people enforcing them that couldn't care less. And then you step into a courtroom, and a lot of times you have judges who, maybe through their own fault, maybe through no fault of their own, haven't really had this education in the basis of the Constitution and our founding, and don't understand what those words mean or how to interpret those words at times. And so it's really important to put that research, that information in front of judges in a courtroom.
Well, that is an interesting point because there are different modes or different beliefs in as people believe in terms of what the role of the judiciary is. There are some people who believe that it's the judiciary's job to right wrongs, right? Justice, right? They're a justice. Their job is to judge a situation based on their own personal concept of right and wrong. And then there are those who believe that their job as a judge or as a justice is to interpret a particular situation as the law and apply the law and the Constitution in their ruling, not to create law, not to institute justice based on their sense of right and wrong, but to use the right and wrong as is dictated by the law and the Constitution. I happen to believe in the latter. I believe that our current Supreme Court is made up of a majority, we can debate on how big a majority, but a majority of people who believe in the latter. But for a good significant amount of time, our Supreme Court has been ruled by people who believe the former.
Yeah, there was a long period around that kind of New Deal era where you had a Supreme Court that was very much issuing opinions, kind of creating law in essence, or were going around and were more concerned about the outcome than they were about the process. And process is incredibly important when you're talking about constitutional law, because even if it leads to an outcome that the court might not like, or that some of the parties might not like, it doesn't matter if you come to the right decision. And there are correct decisions in a lot of these cases. There is a right answer when you're looking at constitutionality a lot of times. And even if it's going to have a downstream effect that people aren't prepared for, right? There was a case that came out of Oklahoma that dealt with tribal jurisdiction, and Justice Gorsuch wrote the opinion, and it basically upended the enforcement of criminal law in Oklahoma. And Gorsuch, whether you think he was right or wrong, but Gorsuch basically came out and said, look, this is where the text and where the statutes lead me, and I can't decide differently if it's going to have a large effect on the enforcement of criminal law in Oklahoma. I have to rule by the letter of the law. And that's really important. And when you get into these constitutional discussions, when you get into constitutional interpretation, it's really important that we're putting good information in front of them, and that we're putting the historical proof, post Bruin, that's even more, or has been confirmed to be important. We've always known it was important, but it's really, really key that that's in front of judges so that they can rule by what that document means, what the Constitution meant when it was signed and ratified, and what the Bill of Rights meant when it was ratified in 1791.
Right. And that's not to say that some of the outcomes weren't societally desired outcomes, or even outcomes that we like, but the challenge is sometimes it's not the court's job to fix it. Sometimes you say, look, there's a problem with this, and the legislature is the one who needs to change the law. It's not the court's job to change the law, which we have seen the court in many cases on some very substantive issues actually rewrite law in order to fit, once again, their determination of right and wrong. And the problem with that is that depends on who the majority in the court is, because in one case it may seem right or wrong. In the other case, when you make a change in the court, all of a sudden the sense of justice or right and wrong can change. And justice really should never change.
Yeah, I mean, it's very clear in the Constitution, right, that the job of judges, there's some debate over how heavy a hand they can use, but it's very clear that they don't have legislative authority, right? They don't have the power to make law. Our system was intentionally designed to divide those powers amongst the different branches. And so it's not proper for judges to come in and fix statutes, or to advance new interpretations that would allow something to survive just to allow it to survive. It is incredibly important that we ensure that these judges are looking at the factors in front of them, and then are making the upvote or downvote based solely on that information and are, ruling on the constitutionality. It's not the role of a judge to step in and say, look, this law isn't perfect, but we can fix it here. If you tweaked it this way, this would be better. I mean, we saw that. Maybe I won't point fingers at any
I
any
think we know
currently
which ones you're talking
sitting
about.
justices. Yeah, but we've seen it happen, and it's incredibly difficult to deal with that sort of scenario. It's dangerous, but that's why we have such a concerted push on litigation too. That's why, you know, FPC doesn't have one case in one state on one issue, right? We have cases across the country on a variety of different issues, not only so that we're fighting for people's rights in every state that we possibly can, but also so that these issues are rising all the way up to the top, and we're putting them in front of circuit courts, we're putting them in front of the Supreme Court, and having the opportunity for that court to weigh in and to upvote or downvote. It's the gladiator, thumbs up, thumbs down on the constitutionality of some of these bills. At least that's how it should be. And so that's how we frame a lot of these issues.
All right, I have one question, and this was kind of a selfish one. A lot of people in the anti-gun community like to say, well, that Heller was the first time when the court actually ruled on the Second Amendment being an individual right. And once again, I am not a lawyer. I've never been to law school. I did not sleep at a Holiday Inn Express last night. But I've always kind of took that to understood that before Heller, you never really. I mean, the plain text of the Constitution said that the right to keep and bear arms shall not be infringed. I've always thought that before that, it's not that they said it wasn't, but just that, it seemed kind of obvious before we started having to rule on cases leading up to Heller. What's your interpretation of their analysis? And then, what would you say about basically what I just shared?
Yeah, I mean, I agree. I've read the 27 words myself. They're not all that difficult. The right of the people. It's pretty straightforward. It's very obvious too when you look back at the discussions that were happening during the founding era, the discussions that were happening during the debates over the Bill of Rights, that the battle, right, was between kind of two factions, the Federalists and the Anti-Federalists. And there was a group of people that wanted to ensure that it was very clear that this new, very powerful federal government that they had created could not, infringe upon people's basic individual natural rights. And I think that's the key. And that's how we got the Bill of Rights, essentially. And that's the key where there's this misunderstanding. So many people look to the Supreme Court to say, oh, well, the Supreme Court has said, or the Supreme Court has not said, right? Prior to Bruin, the Supreme Court had not affirmatively stated that there was a right to possess firearms outside the home. The Second Amendment says keep and bear. And I think we all know what the word bear means. So just because the Supreme Court hasn't spoken on it doesn't mean it's not the case. Beyond that, even, if you understand how our founders viewed and how our framers viewed rights, natural rights, rights that are inherent by your virtue of being a human being, and how they understood government, which was a consent to create a government of enumerated powers. So the way our entire system of government operates is the exact opposite of if the court hasn't said it, you don't have it. It's if we haven't told the federal government that it has the power, then it doesn't have the power. It should be a very straightforward inquiry. There's a whole article on this, Article 1's, first one's, the longest one's, the most important one. They spent a lot of time on it. There's a whole section, Section 8, just lists out things that Congress can do. Last time I checked, regulating firearms was not in Section 8. I've read it a couple times, so if I missed it, somebody can feel free to let me know. There's somebody I should clarify, because somebody's going to post a comment and they go, well, actually, it is true that Congress has the power to arm militias and arm the people. So I think if we passed a law, if Congress passed a law that handed out ARs to anybody over the age of 18, that would potentially be constitutional. I don't see that as a problem that we're probably going to be a problem, air quotes, that we're going to be dealing with anytime soon. But it's just really straightforward. The way that our rights work, the way that government power works, and the way that interaction is makes it very obvious that this has always been an individual right. It is a pre-existing individual right. It doesn't depend on the existence of the Constitution, of our government, of the Bill of Rights. You have the right to possess arms, to defend yourself, both from other people and from a tyrannical government. It is as straightforward as it could be when you look to the history.
Exactly. Hey, how do folks follow the work that you're doing there with the Firearms Policy Coalition at FPC Law?
Yeah, absolutely. So follow our socials. You'll see, at Gun Policy on most things, or look up Firearms Policy Coalition. You can visit us at firearmspolicy.org. You'll see all of our work come out. You'll see press releases coming out all the time on all the work that we're doing, on all the different issues that we're taking on. So follow us there. If you feel so inclined, feel free to donate, support us, support the work, make it so that we can file more lawsuits.
Excellent. Cody, thank you so much for coming on the program. We appreciate you and appreciate all the work that you are doing with the rest of the folks there at FPC Law, and hope to have you back on the program again real soon.
Absolutely. Thanks for having me, Craig.
All right. All right, folks. Well, hey, that was it for Cody, but want to remind you, FPC is a membership organization. We only exist with your help and with your support. So please take a moment, follow the join link in the description of this video and become a member today. Remember, there is no us without you. So please become a member today. As I always say, you can either be part of the solution or you can be part of the problem. Don't be part of the problem. Become a member today. Also, make sure you visit fpcgear.com. It is the place to get all of your Pro 2A swag. Folks, it's summertime. We got plenty of opportunities for you to get tank tops and t-shirts, but we also have hoodies and other good stuff for you to buy in order to promote your support of the Second Amendment. Now, the best part about it is that every dollar that you spend goes right back into the fight for our right to keep and bear arms. So you can support the Second Amendment and you can look good doing it. That's fpcgear.com. All right, that's going to be it for today's episode. We very much appreciate you tuning in. We appreciate you liking and sharing the program and encouraging your friends to do the same. Remember, this is a fight for our civil rights. Got to use them or you're going to lose them. You guys take care.
If you like our videos, follow, subscribe, like, and share.